Almost every legal rule seems to have some exceptions, and the widely held choice of law rule, called the Internal Affairs Doctrine, also seems to have a very prominent exception. The Internal Affairs Doctrine holds that the internal affairs of a corporation shall be governed by the law of the state in which it is incorporated. But California claims that it can govern, through its laws, foreign corporations that are incorporated elsewhere but doing business in California. Let's take a look at the Internal Affairs Doctrine and then California Corporations Code Section 2115 and see if you can understand how they are inopposite. Then we're going to apply Section 2115 to case law. In future videos, I'll talk about the constitutional reasons why the Internal Affairs Doctrine may be required and California Corporations Code Section 2115 may be unconstitutional. The Internal Affairs Doctrine holds that a corporation's internal affairs are governed by the law of the state in which it is incorporated. We have to then determine what are internal affairs, and they predominantly regard the relationship between the corporation, its officers, directors, and shareholders. Most prominent examples include voting rights of shareholders and shareholder lawsuits against directors for breaching fiduciary duties, although certain other procedures for corporations may apply. The Internal Affairs Doctrine, although a widely held choice of law rule, is not universally respected. Some states, most notably California, have attempted to regulate what they call pseudo-foreign corporations, corporations that are incorporated outside the state but are doing a majority of business within the state. Corporations that are incorporated outside the state in which they are doing business are called foreign corporations. And so if that foreign corporation is actually doing most of its business in the foreign state, in this case California, may purport to have control over its internal affairs. California Corporations Code Section 2115 is often referred to as a long-arm statute because California is reaching out and grabbing on to corporations that purport to be governed by laws of other states, and it seeks to regulate them as pseudo-foreign corporations or quasi-California corporations because they have sufficient contacts with that state of California. California Corporations Code Section 2115 says that a foreign corporation is subject to the requirements of the California Corporations Code if, basically, the corporation is doing more than half of its business in California and has more than one half of its shareholders in California. California 2115 does have an important exception. It does not apply to publicly traded companies. The impact of California Corporations Code Section 2115 is actually very significant because so many companies do business in California. California is one of the largest economies in the world and historically has been the largest state economy in the entire United States. So claiming that corporations that do business in California are subject to its rules and not to the internal affairs of the state in which they are incorporated can have a massive impact on corporate governance. The case of Louisiana-Pacific. The case of Wilson versus Louisiana-Pacific Resources Incorporated really highlights the issue and also suggests the constitutional problems with California's long-arm statute. Although, as you'll see, this case, being decided in California, may have had an influence on its outcome. Let's take a look at this case in some detail to better understand the issues with California's statute. First and foremost, as is typical in these cases involving the Internal Affairs Doctrine, there is some sort of conflict of laws. By the way, if you're looking to have an issue spotting tip for when to pick up on an internal affairs doctrine issue, there will almost always be some conflict of law because one shareholder will be suing to require that the law of another state apply. In this case, California requires cumulative voting by shareholders, and Utah permits straight voting. Can the California doctrine trump the Internal Affairs Doctrine? Louisiana-Pacific was incorporated in Utah, so according to the Internal Affairs Doctrine, its internal affairs, which include shareholder voting, should be governed by the laws of the state of Utah. But it also had more than half of its employees, shareholders, and operations in California, so California could claim that Section 2115 applies. In this case, Wilson, the plaintiff, was a minority shareholder, and minority shareholders generally benefit from cumulative voting. It's a way of giving minority shareholders a bit more power, and it's required under California law. Louisiana-Pacific, on the other hand, claimed that it was allowed to use straight voting. Its charter provided for it, and straight voting is allowed under Utah law. So, which law applies? Are we going to apply the Internal Affairs Doctrine and say that the corporation can effectively choose its internal affairs governance based on where it incorporates? Well, this case was held in California, and remember, California is the one who said that they have the right to regulate the internal affairs of corporations that have substantial contacts with that state. Perhaps unsurprisingly, the California Appellate Court held that California law applies. California may impose its law requiring cumulative voting upon a corporation which is foreign but has contacts with California. California had a greater interest, and therefore its voting provisions were applicable under the Constitution, at least according to the California courts. But California is taking a minority approach here. Most courts, especially Delaware, vigorously apply the Internal Affairs Doctrine, and they claim that the Constitution requires them to do so. Let's take a look at another case with very similar facts. In VantagePoint Venture Partners, we have a Delaware corporation with substantial California activity. The difference, though, is this case was decided by Delaware courts. Will that make a difference? Once again, we have a conflict of law that brings up whether the Internal Affairs Doctrine will answer the conflict in favor of the state of incorporation. Here, California requires separate class voting. Delaware permits single class voting. A brief aside on why this matters. For example, in venture finance, investment can occur in series. For example, Series A and then Series B and Series C, D, E, and so forth. If these series have different rights, then they form different classes. And there could be more Series A, for example, than Series B. If that's the case, the Series B would always be outvoted, unless they have the right to vote as a separate class. If they have the right to vote as a separate class, that class can effectively block a transaction. So, class voting gives more power to minority shareholders, just like cumulative voting did. Very similar facts to the previous case. Let's take a look at what happened in this case. VantagePoint Venture Partners had a shareholder, Examen. This shareholder claimed that VVP is required by California law to have separate class voting prior to a merger. This is in fact required by California's Corporations Code. But remember, VVP is incorporated in Delaware. What does Delaware law require? Delaware law permits single class voting, and the Internal Affairs Doctrine would hold that Delaware law governs the internal affairs of a Delaware corporation, whereas California Corporations Code Section 2015 would hold that California's law governs this particular matter of internal affairs. So what result? The Delaware courts held that Delaware law applies. Maybe not a surprising result. But in another video, I'll discuss the constitutional arguments that the court made. What's interesting is both courts talked about the Dormant Commerce Clause, due process, and the full faith and credit clause. Yet, although the facts of both cases were very similar, and although they both seem to apply the same constitutional principles, the Delaware court and the California court came to completely different results. Here, in VVP, the Delaware court found that Delaware law applies because of the Internal Affairs Doctrine, and it pointed out that this provides certainty and predictability, and is justified by the expected interest of the parties who are involved with the corporation. In other words, the shareholder should know that Delaware law applies, and so has no right to complain when it does. The Delaware Supreme Court focused on the value add of the Internal Affairs Doctrine, and it gives certainty that a corporation will only be subject to the law of one state. Are you surprised that a California court would impose California law on a Utah corporation? Or that a Delaware court would not impose California law on a Delaware corporation? While these courts looked at similar constitutional principles and very similar facts, perhaps they were motivated to come out somewhat differently. Delaware is a relatively small state with a relatively small economy, of which corporate taxes are a huge part of its revenues. Corporations incorporate in Delaware because they want to be governed by the Delaware General Corporation Law, whereas California is a huge state. Not many corporations necessarily want to incorporate there, but they want to do business there. And so California and Delaware are very different states with very different interests. Perhaps that had some bearing on the ruling that came out. In conclusion, there persists a division in the law. California claims that its corporate law governs the internal affairs of corporations that do more than half their business and have more than half their shareholders in California, whereas Delaware and other states have refused to apply this long-arm statute. The question is simply unresolved at a federal level. The U.S. Supreme Court has not yet determined whether California Corporations Code Section 2115 is constitutional or not. Additional topics related to this are whether the U.S. Constitution requires the Internal Affairs Doctrine through the lens of the Due Process Clause, the Commerce Clause, and the Full Faith and Credit Clause. Are pseudo-foreign corporation, long-arm statutes constitutional or not? That's for the next video. Thanks for tuning in.